and myself. This is a committee that is investigating more than anything else the ultimate right of free speech and the First Amendment. So as we go on with the rest of this hearing, I would admonish all of us to remember that it's not the First Amendment or the Second Amendment or the Fifth Amendment or the 10th Amendment in a vacuum. We have to respect them all. The gentlelady who has departed was entitled to assert her Fifth Amendment, although there's some questions about how it was done. There can be no question that we have to respect it. Additionally, that her assertion is not to be viewed or used during this hearing to make any determination plus or minus as to actions that were taken. We have the Inspector General with us today. We have other fact witnesses, and this committee has more than 10 additional witnesses that will be called either to hearings or to interviews already on the schedule. I believe that this committee has a long history of very few during my tenure of 12 years of these occasions, and we should not use this either for political gain or for any indication that it is anything other than somebody's right. It is the committee's work to find out what went terribly wrong. I'll take one liberty mentioning Mr. Cummings' earlier statement. At this point, this committee is not investigating wrongdoing for political purposes by high-ranking individuals in or out of this government. We are investigating something which has now been entered as fact, that wrongdoing occurred, and occurred over a group, and that group happened to be keyworded things that are generally called conservative. In my research on this, and I think Mr. Cummings would agree, this is not new to government. This has happened before, and it has not always been conservative groups. So as we go through this, I would ask all of us to avoid talking about who was liked by President Bush, who is liked by President Obama, who is liked by Republicans or Democrats. Let's all be Republicrats and Democrats today. Mr. Cummings.
Mr. Chairman, first of all, I appreciate you saying what you just said. I agree with what you just said. And I would associate myself with your words.
Mr. Chairman?
Thank you. What purpose does the gentleman seek recognition?
Gentleman, you'll just for 1 minute?
A fraction thereof.
Okay. I just want to say I appreciate what the chairman said. I think he's right on target, but the irony is inescapable. Ms. Lerner gets to exercise her constitutional rights, but she won't stay here and answer questions about the constitutional rights of thousands of Americans who were denied by their actions.
I think the gentleman, it is this committee goal to get to the truth. If we have to go circuitous routes, we will eventually get there. The dots will be connected. With that, Mr. Woolen, would you move over? It'll be less distracting, and we'll remove the other chair. Actually, I'll take note of the gentlelady's opening statement. She made it very obvious with 90,000 IRS individuals, 900 working for her, and more or less 9 out of 900 involved in this, or maybe slightly more. We're talking about a fraction of 1% of the IRS, and I join with the gentleman in recognizing that this is not to disparage the men and women of the IRS. Mr. Woolen, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Issa, Ranking Member Cummings, members of the committee, thank you for the opportunity to appear before you today. Last week, the Treasury Inspector General for Tax Administration, Mr. George, published a report on the Internal Revenue Service's use of inappropriate criteria to identify tax-exempt applications. Like President Obama and Secretary Lew, I believe that the activities described in the report are absolutely unacceptable and inexcusable. The IRS must operate without bias or even the perception of bias. It must act in an utterly nonpartisan manner. It must act with the utmost integrity. The IRS did not do that here. Upon learning of the IG's findings, President Obama and Secretary Lew took immediate action. First, within 24 hours of receiving the IG's report, Secretary Lew asked for and accepted the resignation of the acting commissioner. The next day, the acting commissioner for tax-exempt and government entities tendered his resignation. The day after that, the President appointed Danny Werfel to be the new IRS Acting Commissioner and charged him with holding accountable anyone responsible for improper conduct. Second, Secretary Lew instructed Mr. Werfel to implement fully and promptly all 9 of the recommendations in the IG report. Secretary Lew also directed Mr. Werfel to examine and correct any failures in the system that allowed this behavior to happen. Third, the Secretary asked Mr. Werfel to conduct a broader review to see whether the inexcusable conduct reflects larger management failures and cultural issues at the IRS that require systematic change. Secretary Lew directed Mr. Werfel to take action and implement the necessary changes. Within 30 days, Mr. Werfel will report back to Secretary Lew and the President on his progress and on any future actions he expects to take. Before I describe Treasury's interactions with the IG related to this audit, it is important to underscore 2 critical points. First, there is no indication that Treasury was involved in the improper conduct at the IRS. The IG report did not find any evidence that Treasury or others outside the IRS had any role. Mr. George confirmed this point in his testimony before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. Second, the improper conduct already had ended by the time Mr. George informed Treasury of the fact of his audit. Mr. George's report states that the improper conduct ended in May 2012. Mr. George has testified that he first notified Treasury of the fact that he was conducting an audit in June of 2012. At some point in 2012, though I do not recall precisely when, Mr. George notified me, at his initiative, that he had undertaken an audit of the IRS's review of tax-exempt applications. He told me only of the fact that he had undertaken such an audit and did not provide any findings. That is my recollection, and that is what Mr. George testified before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. In that conversation, I told him that he should follow the facts where they lead. I told him that our job is to stay out of the way and let him do his work. I told him to let us know if he wanted our help and otherwise to let us know when he had more to tell us. I understand that Mr. George also notified this committee in July 2012 that he had begun his review. And similarly, in October 2012, he provided a notice on his public website that he was conducting his review. Again, to be clear, Mr. George told me that he was conducting an audit, and I told him to follow the facts wherever they lead. Our core principle is that we do not interfere in any way with the independent review of an Inspector General. When an Inspector General tells us he is conducting a review, we step back and leave him to do his work. That is how the process functions, that is how the process should function, and that is how the process functioned here. Let me reiterate that there is no indication that Treasury was involved in the inexcusable behavior at the IRS, and Treasury only learned of the fact that the IG was conducting a review after the unacceptable conduct had already ended. It is important in this context to make clear that Treasury's longstanding practice, spanning Republican and Democratic administrations, is not to involve itself in the details of the IRS's administration and enforcement of the nation's tax laws. It is critical that the nation's tax laws are administered and enforced in a way that neither involves political influence nor the perception of political influence. This is particularly true with respect to decisions affecting specific taxpayers. Over the past 12 days, President Obama and Secretary Lew have taken decisive action to address what happened at the IRS. The President named a new acting commissioner, and we charged him with holding responsible parties accountable and with taking immediate action to prevent these inexcusable acts from happening again. Treasury is committed to taking all measures to restore the public's confidence in the IRS, and toward that end, we have asked the IG for its continued assistance, and we are cooperating fully with this committee and with the Congress. Thank you again for the opportunity to appear before you today.
Thank you, Mr. Willen. I'm going to comment that I've never heard a defense of not knowing, and I'm disappointed. I'm going to go through a line of questioning primarily with Mr. George. Mr. George, before the Ways and Means Committee, you told Representative Danny Davis the following. Our audit, sir, began with the request of congressional staff in what I want to give you I want to give you the exact date, sir. I do not have it here. March 1st of 2012 is when there was an initial contact with the Government Reform and Oversight Committee and our audit began, or roughly, and then you go on with May or March, et cetera, et cetera. So essentially, this began in your mind when you were made aware of it in March of 2012 by members of my committee, staff members of my committee, correct?
Yes.
So, oddly enough, we have with us, and put it up on the board, from Holly Paz, a document just released to us, I guess in preparation for yesterday's interview, that says, forward TIGTA document request, the following are issues that could indicate a case to be considered a potential Tea Party case and sent for secondary screening. 1, Tea Party Patriots of 912 Project. 2, or number 4, statements in the case file that are critical of how the country is being run. Now, that's May 20th of 2013. To your knowledge, is that that is essentially the result of an internal investigation done by the IRS, not your investigation? I'm sorry. That's July 23rd. I'm looking at emails, which unfortunately are this year. But that's July 23rd, 2012. Is your understanding that the IRS concluded that they had wrongdoing through their own internal investigation by July 2012?
I have no information on that, but let me consult with my counsel.
I can't.
I have been informed that they conducted an internal review, sir, that was completed before that period.
Okay, so it's your testimony that, in fact, independent of your activity, Mr. Schulman's reports conducted and concluded wrongdoing and could have, in fact, reported that up the chain and taken appropriate action independent of your activities.
That is certainly an option, sir.
So, Mr. Schulman, before I go back to Mr. George, it was your watch. Your people did an internal review. How is it you did not know that things were rotten in your shop in time to not only make sure it stopped and stayed stopped, but in fact the Treasury, your boss sitting next to you, was aware of it?
I said that I learned about this sometime in the spring, and by this, I mean I learned the fact that there was a list and the fact that Tea Party was on it.
Okay, so you knew at that time that you had mistreated Americans within your organization and saw no need to report it up the chain. Is that your testimony?
My testimony is that at that point, I had had a preliminary verbal report. I had been told at that same point that the activity was being stopped, and I was told that the IG was looking into the matter.
Stop there. I don't really care about the IG right now. The IG probably prompted the internal report. The IG, in fact, has been the reason that we didn't hear about this until long after the election, till months or actually a year had gone by. I'm asking you a question. It was your job to make sure people weren't abused. It was your job to stop abuse, but also to report it. Americans had been injured by the activity, wrongful activity of your organization. You say you got it vocal. I don't care that the IRS doesn't keep paperwork. I know when I have to pay my taxes, I don't do it based on what I say I made or what I say my deductions are, that I need paper. However, you knew you did not report up, or did you report up to anyone else within your chain?
I had some of the facts, not all of the facts. I had no idea of the scope and severity. I didn't know the full list. I didn't know who was on the list.
I'm not going to belabor that. I'm not going to belabor that because I don't know has been your answer previously. I'm going to move back to the IG. Mr. George, September 24th, 2012, committee staff mentioned your report would be ready in September. Now, these are exchanges we're putting up here that are back and forth. They're not all personally with you. So September 24th, 2012, the answer to our request about this IG report was field work for this audit is still ongoing, meaning we don't get an answer. December 18th, 2012, any update on this? Sorry for the delay response. I was studying for a final. Okay, that's when it was pushed off to March. These are staff. Committee staff just wanted to know, to check on the progress of this. This is February 12, 2013. Of this, are you at a point where you can schedule a briefing? from your organization. We are leaving no stone unturned. This is February 22nd of 2013. We won't be able to provide a detailed, substantive briefing until late April, early May. My time is limited, so I'll put the rest in for the record. Mr. George, I could go on as late as May 9th, where the committee staff said on the 8th, can we go ahead and schedule a briefing? May 9th, I'll get back to you. And it goes on. Mr. George, this committee and the entire Congress has existing laws. Yesterday I spoke before all of your fellow IGs. Under existing law, you have a peer-level report of substantial misconduct or problems, including waste, fraud, and abuse. The Act describes your establishment, which meaning, in this case, the IRS, and Congress in the same sentence. On August 3rd, this committee, I sent you a letter explaining the 7-day rule, explaining the statute as it has been written for decades. You have a responsibility to keep us continuously and, according to statute, equally informed. In this case, it appears as though you certainly did not. Would you agree with that?
No, actually.
Okay, so when you conducted day after day after day with Mr. Schulman's subordinate, Ms. Paz, one after another interviews in which she's in the room, she's listening to all of these, you're doing that. You know at some time, and I'm going to close with just a question, on what day did you know, over this year period, did you know personally that in fact the IRS had abused Americans in the process of approval? What was that day? What was the aha moment? And didn't you have an obligation to report that to Congress at that time?
Mr. Chairman, I have a detailed timeline which goes from almost month to month as to the interactions that we had with your staff and then subsequently with the commissioner as well as with officials at the Department of the Treasury. And I would appreciate the opportunity to give you a sampling of
We're going to accept that, and I just want to close, and then I'll let you take as much time as you need. If your timeline essentially says you kept us informed so we knew that, in fact, there was a pattern and could speak to Ways and Means to find out that hundreds of people, hundreds of organizations still languished not being approved, even after, quote, the abusive behavior began, they still didn't get their answer in a timely fashion. And if you're saying that you informed Mr. Woolen so that he would understand what was going on, or others at Treasury, and you informed us, and Mr. Schulman, here's my problem. Mr. Schulman has already said under oath he didn't know. Mr. Woolen has already said they didn't know. And although I'm not under oath, I have reviewed my committee staff documents, and of course it's a bipartisan relationship. We certainly did not have the information in any way, shape, or form that could be understood so that congressional action could occur until practically today.
Mr. Chairman, there are established procedures for conducting an audit, and once again, this is an audit. And to ensure fairness and to ensure that we are completely accurate with the information that we convey to Congress, we will not report information until the IRS has had an opportunity to take a look at it to ensure that we're not misstating facts.
Mr. George, that is not the statute. That is not the statute.
But it would be impractical for us to give you partial information which may not be accurate. It would be counterproductive, sir, if we were to do that.
Well, I appreciate that. I've taken a lot of time, and I'll give the same amount of time, of course, to my ranking member. But this committee, last August, made it very clear that the statute as written does not give you the ability to, or any IG, to use us as a whipping boy when you want to, and in fact keep us in the dark until an investigation is completed. Mr. Schulman, I will admonish you, as best I can as one member of government to a former member of government, that in fact there was a there. People in your own internal operation knew. If you didn't know, you were derelict in your duty, or your management style was such that you didn't get informed. Either way, that is certainly not something you should be proud of. To the extent that you did know or suspected, Mr. Woolen standing here or sitting here implying the Treasury didn't know is astounding. Mr. George, fact is, if these individuals did not know, then you did not allow them in a timely fashion to take corrective action, even while you continued with what could be a criminal investigation / audit. In the case of Congress, I will work with the ranking member to reiterate with clarity Congress's absolute right to have, according to the statute, continuous information, and that is not waiting for the final conclusion. The Act did not say audits and investigations shall, upon their conclusion 7 days after being given to the principal, be delivered. That is not the portion that we referred to in August of last year. I'll give you the last word.
Sir, I would welcome the opportunity to work with you and other members of Congress to clarify exactly what the quote-unquote 7-day rule is under the Inspector General Act. But once again, I think it would behoove all of us to ensure that accurate information is given to Congress so that we don't act precipitously. And as you, I'm sure, are aware, many times when information is conveyed to the Hill, it is sometimes not retained in the Hill, and on the Hill rather, and that is not fair to the people who are investigating or
I apologize. I said I would give you the last word, but right now we're seeing an awful lot leaking out of the administration, and the IRS leaked in this particular case. This organization maliciously leaked this information. Mr. Woolen, the only other thing, and I apologize, Mr. Cummings, I'm going way past where I ordinarily would. It is our understanding that today, as we speak, dozens, if not hundreds, of applicants who have been waiting years are still being essentially denied justice. If they continue to be denied justice, every clock tick is a clock tick of you're not meeting your obligation. Mr. Shulman has left office. He left office without making sure that those, quote, Tea Party groups and others had a legitimate adjudication in a timely fashion, which means they were already overdue because of the prior abuse. To the extent that there's one applicant that comes forward to this committee that today has not been approved or denied for cause, you are now derelict in your duty. Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Schuman, I want to pick up where the chairman left off with you. You were the head of the IRS from 2008 to 2012. All of this activity happened on your watch. The development of these terms, the use of the terms, and the targeting of conservative groups. The IG called this activity inappropriate, but I think it's far worse than that. It undermines the public trust in the IRS, and that's very, very unfortunate. I want to ask you about two major issues. First, I'd like you to address the allegation that the administration was engaged in some kind of effort to use the IRS to target its political enemies. So I want to walk through this very quickly with you. Who nominated you to be the head of IRS?
President Bush.
Are you biased against conservative groups?
No.
Do you think they deserve more scrutiny than liberal or progressive groups?
No.
Did you ever order IRS employees to target conservative groups?
No.
Did you ever encourage or prompt them to do so in any way?
No.
Did you ever receive instructions from anyone at Treasury to target conservative groups?
No.
Did you ever receive instructions from anyone at the White House to target conservative groups?
No.
So these misguided actions, Mr. Shulman, were initiated by IRS employees. They were not part of any administration conspiracy, and you had no knowledge of them before 2012. Is that right?
I personally don't remember ever hearing about this until the spring of 2012.
Now, we've dispensed with that issue. I want to address the very serious question of why you failed to inform Congress about these activities last year when you learned of them. And I must tell you, Mr. Schulman, I want to remind you that you are under oath. And I tell you, when I watched your testimony the other day, it was very troubling. As a matter of fact, some of your testimony this morning has been troubling. And so I want you to give us your answers, and I know you will be truthful. Members of Congress wrote numerous letters to you expressing concern that conservative groups were being targeted by the IRS. When asked about these allegations at a hearing before the Ways and Means Committee in March 2012, you answered, and I quote, "There is absolutely no targeting," end of quote. Even if you did not know it was going on when you testified, you learned about it soon after, but you never corrected the record. You were the head of IRS. Why didn't you ever come back to the Congress to explain that you were mistaken?
So, what I can recall is that I learned about the list after that testimony. And when I learned about the list, I learned two other things. First, I learned that the activities were stopped. So by the time it got to me, the list was no longer being used within appropriate criteria. And I also learned that the matter was in the hands of the IG. And my standard procedure as head of the IRS is when I knew something that sounded of concern, as the chairman called smoke, and I didn't have all the facts. I didn't know what was on the list, exactly how it was used. Were there liberal groups as well as conservative groups? I didn't have the facts. And it was in the hands of the IG, that the IG would do a thorough review of the matter, and when he had all of the facts, would report that to the IRS, to the Treasury, and to Congress. And so at that point, I didn't have anything concrete. I didn't have a full set of facts to come back to Congress or the committee with.
That answer would be more acceptable if you had not given the answer that you did in March 2012. When Congress asks you a question and then you say these words, there's absolutely no targeting. It seems to me that even given what you just said, you knew that Congress was concerned about this issue. You knew then that the information, you just said it had been corrected. But it seems to me that if you say to the Congress, absolutely not, absolutely no targeting, it seems to me that you would come back, even if it was a phone call or a letter or something. I mean, common sense. A reasonable person would expect you as the head of the IRS communicating with Congress to come back and do that. You didn't feel that way, though.
I guess I would repeat.
I don't want you to repeat.
In March,
I don't want you to repeat. I take it that you disagree with what I just said.
At the time I learned about this list, I felt I was taking the appropriate actions and that my course was the proper one, and I still feel that way today.
Well, I'm sorry, that's simply not good enough. It's simply not good enough, Mr. Schulman. The IRS conducted an internal investigation of its own. Not the IG investigation, but your own investigation. You personally knew there was a target list. You knew it said Tea Party on it. You put new processes in place, and you took personnel actions. You reassigned at least one individual back in 2012. Come on, Mr. Schuman. I mean, help us help the taxpayers. Am I missing something?
So
Did you have an investigation? Was there an internal investigation?
I never understood that word of internal investigation.
Did you ever reassign at least one person back in 2012?
Not that I was aware of.
You don't know that?
To the best of my knowledge, I was not involved in the reassignment of people in the determinations unit. I have no recollection of that.
So when you learned about the targeting, apparently you made some kind of inquiry because you said you found out that it had been resolved. Who did you go to and who told you that it had been resolved, and what did they say the resolution was? You were the head of the IRS.
I was the head of the IRS.
And you got Congress people that were upset about targeting. They had been asking questions. You had come and said there was absolutely no targeting. And so help me with this.
Yeah. First of all, let me express this is a very serious matter, and I fully recognize that. This was a 90,000 person agency, and this was a unit that was working on applications by definition for organizations that had political activity. My general operating style as the only one of two presidential appointees in the building was to have the responsible career officials be the hands-on people in sensitive case matters that involve political activity. So my deputy informed me of this.
And who was your deputy?
Steve Miller.
Okay.
And at or about the same time, he informed me that we found this list. It had Tea Party on it. I have no memory of having knowledge of what was on the list, what else was on the list. To the best of my understanding, didn't know how it was being used, didn't know if it also had the target word progressive on it. He said, look, it's not being used anymore, it's being stopped. The IG is looking into it, and I was aware that some of these cases were languishing because we'd gotten letters from Congress, and he said, and we put extra people on there and we're moving cases. That's my memory of this. And as I said, once the IG has this, my practice was to support IG reviews and investigations, but not interfere with the full confidence that he would get the information.
But this has nothing to do with interfering with an IG investigation. This is merely coming back to Congress. You got to understand why I'm getting to this. Remember in my opening statement, I said two words, just two. Truth and trust. Truth. And we want to be able to trust the IRS, but for this moment, on this day, we need to be able to trust your word. And what I'm saying to you, you keep telling me, you act as if something that was of paramount concern to the Congress, paramount concern to the chairman of the top investigative committee in the Congress, and you find out information and you know it's a concern. Did you get upset when you heard this from Miller?
I had concern. I didn't know the scope and severity of it. As head of the IRS, I felt comfort that the IG was going to look into it, find the scope and severity, and report it back to Congress at the appropriate time.
Mr. Shulman, as I close, you headed up an organization. You were responsible for that organization. You don't even know that an employee was reassigned back then. You did not come back to Congress and let Congress know what you knew. You didn't have to give us a lot of details. It's just that if I had said something to Congress and it was just the opposite of what it was, seems like just logic would tell me to go back and say, look, I thought that I acted on certain information that I didn't have. Now I have it. this is what it is. I have limitations. There's an IG investigation going on, but at least I want to set the record straight. I take it that you disagree with what I just said.
I told you before, I think I took the proper course.
Very well. Thank you, Mr. Chairman.
Thank you, Mr. Cummings. We now recognize the gentleman from Florida, Mr. Micah.
Thank you, Mr. Chairman. And I guess look around, I end up being the most senior member of this panel, and having seen a number of scandals and also participated in various investigations. I don't think I've ever seen any investigation or review by this committee or subject that has so riveted and shocked the American people. Going home last weekend, almost to a person, everyone asked me about this. Maybe it's because what Mr. Cummings said, people expect truth and trust in government. Everyone, just about everyone that I deal with or talk to pays taxes or has to deal with IRS. So this has really come home to them in a very personal way. They want us to get to the bottom of this. And Mr. George, so far IRS would have us believe that this is a bunch of lower-level IRS employees who got around the water cooler one day in Cincinnati and said, who do we target this week? And they sort of got out of hand, and that's the end of the story. Do you think that's the end of the story?
I do not, Congressman.
You do not. And neither do the American people. What's disturbing, too, is I made this little chart this morning. Sort of the pattern. This isn't very fancy. The staff, not highly paid graphics here. But, this all started back in 2010. And here's a long list, Mr. Schulman, of members of Congress who contacted you. And I see Sarah Paul Ingram, I see Lerner, on and on. Not just people like Mr. Eisen and myself of this committee, but senators and everyone else asking questions here, all the way through. And for 27 months, you said you did all you could to expedite those requests. For 27 months from here to here, nothing got done. None of those were approved, were they? Not one. Not one.
I defer to Mr. George, who's
I'm
looked
just
into the
telling
details.
you, we checked 27 months, none. So what you're saying it doesn't hold truth. Now, the thing, too, and you may disagree with the Tea Party or conservative group, so whether you're liberal or conservative, Americans under the right of this little document, the Constitution, maybe not in the framework of the Constitution, but right at the beginning, we have 10 amendments, the Founding Fathers to pass it, put in there. The first is the freedom of speech. You closed down or gagged for 27 months people, or folks who work for IRS, closed them down for 27 months between 2010. We were discussing policies of expanding government, of health care important to the American people, of a whole host of issues, plus the election coming up. For 27 months, you gagged or closed down the legitimate right of those folks to participate in the process under the Constitution. Do you disagree with that?
Let me premise that I was, because on purpose, I was not heavily involved in.
Okay.
Let me finish. In tax exempt organizations, but my best understanding is people were not closed down during this time. No, my best understanding though is that people were operating at that time, and there's also my best understanding is there's a whole nother option for someone to be a 501c4.
Did you know, Mr. Miller,
they don't need to apply.
Did you know Mr. Miller or had sent or had you sent approve of sending Ms. Lerner down to look at this?
Mr. Miller informed me sometime in the spring that he was going to look into the matter further and find out what was going on down in the
But did you know Ms. Lerner was doing it?
My interactions on this
And Mark.
were directly with my deputy.
Okay. Well, did you know, for example, Ms. Lerner, who's the head of it, got a total of $740,000 between 2009 and 2012, over $42,000 in bonuses. Would you check off on bonuses? And this is the one that used to sit there and was going to testify but didn't. Do you check off?
Until now, that number does not sound familiar. I didn't individually make decisions, but I probably signed off on overall agency
And have you
compensation.
participated in the political process? Could you tell the committee of your political participations, donations?
My whole life?
Well, yes. Are you? I don't know your background. I heard you were appointee of one administration, but what is your history of participation?
My full life history of participation in politics, I don't.
The gentleman's time is soon to
I
expire.
don't
We
want
could take a short version,
let me not
please.
try to take
Contributed, for example, to parties and groups.
Have I?
Yeah.
In the past? To the best of my recollection, I have.
You have?
Yeah, I mean, sorry. To the best of my recollection, I have. I haven't in a long time. Didn't make any contributions while I was IRS commissioner.
Thank you, Mr. Chair.
The chair now recognizes the gentlelady from New York, Ms. Maloney.
Thank you, Mr. Chairman. I believe we are united in this committee in being outraged at the alleged targeting of Americans for their political beliefs by the IRS. Mr. George, is it illegal to target Americans in the IRS for their political beliefs? Is it illegal activity?
The way in which the Internal Revenue Service exercised their authority in this matter at this stage, Congresswoman, we do not deem it illegal. We do not believe that it was illegal what they did.
Do you believe it should be illegal to target Americans in the IRS for their political beliefs?
Well, the IRS currently has policies which state that if there are willful actions taken that would violate civil rights of a taxpayer, which would in other ways falsify documents, destroy documents, there are illegal activities that the Internal Revenue Service employee can engage in. But I have to note, Congresswoman, that the Secretary has delegated tax policy questions to the Assistant Secretary for Tax Policy, and I have to defer to him.
Well, I personally believe it should be illegal, and I find it very troubling. The allegation that the IRS not only targeted Americans for their political beliefs, but also withheld information from this committee. And specifically, Mr. George, in roughly March of 2012, Chairman Issa and Representative Jordan sent you, or rather Mrs. Lerner, asking for information about the potential targeting of Tea Party organizations by the exempt organization office. Is that true? And that in response to that letter and media reports and requests from this committee that you started an investigation of and reviewing the applications for tax-exempt status. Is that correct?
Actually, it is correct, but we had conversations with staff of this committee prior to the receipt of that letter.
But you did begin an investigation.
Yes, we did.
And your staff informed Chairman Issa and this committee about that investigation, correct?
That is correct.
Mr. Shulman, in March of 2012, the IRS began conducting its own internal review of the tax-exempt organization division. Is that true? Did that happen? And is that a common occurrence? Why did the IRS start their own internal review when you have an IG whose job it is to do the internal review, and he had notified Congress that he was doing the review?
I don't have direct recollection of the time frame, but I read the report and saw that in the report in late March, at least in the report, it said that my deputy asked someone to go take a look. And I think that's what you're talking about.
Well, absolutely.
I think my understanding at the time, I'm sorry.
Well, what I'm talking about is you did not inform the committee that you were doing an internal review, which